Good morning, this is your Kelso Report for Thursday, November 8th, and I'm your host, Clark Kelso. We begin today with an in-bank decision of the Ninth Circuit denying a petition for habeas in a death penalty case. And then we see what happens when a plaintiff fails to effectuate service of process under the Hague Convention, whether a person racing through a red light at a crowded intersection can be convicted of assault with a deadly weapon, and what happens when someone who is trying to buy a copyright fails to secure the copyright owner's signature on a written conveyance of the copyright. We begin with the Ninth Circuit. The Ninth Circuit in bank rejected yesterday a habeas challenge to a death penalty conviction back in 1983, arising out of the murder of two people during a robbery. The petitioner is Hispanic. The victims were white, and during voir dire, the prosecutor peremptorily challenged 75% of the Hispanic surnamed veneer persons, but challenged only 26% of the white, non-Hispanic surnamed veneer persons. Trial counsel failed to object to the challenges under the California Supreme Court's decision in People v. Wheeler, and the habeas petition alleged ineffective assistance of counsel. Now, to win, the petitioner needed to establish that counsel's performance was deficient and that there was a prejudice under the United States Supreme Court's Strickland test. Well, the Ninth Circuit found no prejudice, and no need then to evaluate counsel's performance. As for the lack of prejudice, the majority noted that 5 of the 6 challenges to the Hispanic surnamed veneer persons had adequate non-discriminatory explanations, that 2 Hispanic surnamed persons were seated on the jury, and 1 Hispanic surnamed person was seated as an alternate. In these circumstances, the court concluded that it would have been very difficult to establish a prima facie case of discriminatory use of peremptories under Wheeler, and there therefore was an insufficient showing of prejudice under Strickland. This looks like the end of the habeas road in this case, since I doubt the Supreme Court will grant review of the Ninth Circuit's decision. Next, we turn to 3 California Court of Appeal decisions. First, to secure personal jurisdiction over a defendant, the plaintiff must establish that the defendant was properly served with the complaint. If a defendant voluntarily submits to the jurisdiction of the court, no issue arises. But if the defendant files a motion to quash an alleged service of process, it falls to the plaintiff to present evidence discharging the burden of establishing valid service. Well, the plaintiff failed to meet that burden in LaBelle v. Mott. The plaintiff knew the defendant was living in London, England, but did not know her address in London. So instead of trying to serve her in London, the plaintiff served the defendant's mother, who lived in California, and claimed that this constituted valid substitute service. The Second District disagreed. Because the defendant was a resident of England at the time service was attempted, the plaintiff needed to show either service of process consistent with the Hague Convention regarding service on an individual in a foreign country, or a proper basis for why the Hague Convention did not apply. The plaintiff admitted not complying with the Hague Convention, and her excuse was that she did not know the defendant's address in London. She argued that the Hague Convention did not apply because Article 1 of the Convention provides that the, quote, Convention shall not apply where the address of the person to be served with the document is not known, close quote. Well, this argument was not good enough for the court, which interpreted Article 1 as still requiring some reasonable search or inquiry to find an address, before concluding that an address was not ascertainable. Since the plaintiff had conducted no search at all for the address, the court decided the plaintiff had no excuse for not complying with the Hague Convention. In both torts and criminal law, determining exactly what a defendant has to intend in order to be found liable or guilty is a frequently litigated question. In People v. Asnovola, The 2nd District confronted this question in the context of a charge of assault with a deadly weapon. The weapon in this case was a car that was driven by the defendant, and the intent question arose when he drove the car at a high speed through a red light at a busy intersection, striking several cars. The defendant, of course, argued that he did not intend to assault anyone. In fact, he hoped to clear the intersection. The 2nd District rejected this argument, noting that assault with a deadly weapon requires only proof of an intentional act committed with knowledge of facts that would lead a reasonable person to realize that physical force would be applied to another as a direct and probable consequence of that act. The court concluded that a reasonable person would know that force would likely be applied to another as a direct and probable consequence of running a red light at a busy intersection. So the court affirmed the defendant's conviction. Finally, the law at times requires writings or signed writings for legal transactions to be recognized and enforceable. Now, some of these requirements are loaded with exceptions, where the failure to produce a signed writing may not be fatal to a subsequent claim. The statute of frauds in the law of contracts is a good example of a signed writing requirement where courts recognize quite a few exceptions. By contrast, when it comes to the transfer of ownership and a copyright, the signed writing requirement is very strictly construed. Section 204A of the Copyright Act provides that, quote, a transfer of copyright ownership, other than by operation of law, is not valid unless an instrument of conveyance or a note or memorandum of the transfer is in writing and signed by the owner of the rights conveyed. In MVP Entertainment v. Frost, the 2nd District applied Section 204 to affirm summary judgment against the plaintiff, MVP Entertainment. MVP Entertainment thought it had a deal with Frost, the author of a story, for the transfer of the copyright in the story to MVP so that it could turn the story into a movie. But MVP never secured a signed transfer of ownership or other signed writing from Frost. And when Frost changed his mind, MVP sued. But they discovered the absence of a signed writing, effectuating the transfer of ownership, was fatal to their claims, and the court affirmed the dismissal on a motion for summary judgment. That's it for today's Kelso Report. Have a great day in the law.